Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Good morning. Be seated. Welcome to the 4th Department of the Appellate Division. Just a couple quick reminders. It looks like we have a lot of repeat customers, but just remember that the judges here have all read the records and briefs. You don't need to give us a recitation of the facts. Get right into the arguments and focus mostly, if you can, please, on your key contentions. That would be very helpful to the panel. And as a reminder also, we do not take rebuttal, but we do allow applications for consideration of post-argument submission. So with that, let's start with the first case. (116) People versus Manila, and I think this is by video.
Your Honor, remote counsel is not checked in.
Okay, we'll deem that submitted. Go to the next one, which will be People versus Jermaine Patterson, number 118. Counselor, can you hear us okay on the video?
I can, Your Honor. Good morning.
Good morning to you, sir. We're all set for your argument.
Okay. Paul Skip Lazier, of counsel to the Monroe County Public Defender for Jermaine Patterson. There are three problems with this case. One is that there was insufficient evidence that a burglary ever occurred at Justin Kennedy's home. Second, Mr. Patterson was prevented from testifying by the court's egregious Sandoval ruling. And third, his persistent violent felony sentencing was illegal. With respect to the insufficiency, Mr. Patterson faces life in prison for a daytime burglary of an unoccupied residence when there was no corroboration that that burglary ever occurred.
Counselor, can I interrupt you on that, please?
Yes.
It looks to me like both parties kind of recognize we have a situation here with, did county court neglect to decide the TOD motion?
Yes, Your Honor. I take that as a denial of that motion. And if it was not a denial of course, the people agree that since counsel did in fact make the motion, that it's preserved. If the failure to complain about the lack of a specific ruling renders it unpreserved, then there was clearly ineffective assistance. So either way, the court should reach.
Yeah, there might be a third option, Mr. Leisure, in terms of the case law that we have, and I don't know how this will pan out, but just for your consideration, sometimes our court holds the case and remits it for the court to make that decision, because I'm not sure that we can make it under Concepcion and LaFontaine. That's sometimes a concern about that. At least I think that's the issue. So anyway, go ahead with your argument. I just wanted to give you that question. Thank you.
Well, just quickly with respect to Concepcion and LaFontaine, there was a conviction. And so I believe that Mr. Patterson, that there's a ruling adverse to him because of that. Because obviously if the court would have granted it, then we wouldn't be here. So with respect to the evidence, the only hard evidence against Mr. Patterson was the possession of Mr. Kennedy's Nintendo. That's the only hard evidence. There was other evidence, but none of it corroborated that a burglary ever occurred. Mr. Patterson first said that he did not commit a burglary. So the first statement is that he just possessed stolen property. Then he eventually came up with a story that somebody named Porter entered the residence, and that conveniently allowed him not to say how entry was gained. My position is that he didn't know. And the fact that he knew the list of things that were stolen is consistent with and corroborative of possessing the stolen property from Kennedy's home, but not with actually having been a burglary. Now, there are several things about this that break the chain of inferences that would permit corroboration of the burglary. First, there was no sign of forced entry. And most importantly, when Kennedy left his home that day, his roommate was there. Did the roommate take the stuff? Did the roommate let someone else in the house? None of the roommate's property was stolen. So there's numerous reasons that a burglary did not occur, or possibilities that burglary did not occur, and precious little corroboration for anything other than possession of stolen property. Yes, it's true. Mr. Patterson was aware of Mr. Kennedy's home. He had dropped him off there. He knew him. But that's opportunity only. That's not evidence of burglary. With respect to the Sandoval ruling, I'm aware that the court does not often disturb a Sandoval ruling. In fact, very rarely does so. I'm suggesting that this is the case where you should, for two reasons. One, it is particularly egregious because these priors were 10, 17, 20, 22 years before. And the court permitted inquiry about how long he had spent in time, therefore telling the jury these were serious crimes that he was guilty of. The second reason the court should reach it is because the trial court applied an incorrect reasoning that should be corrected, and that is it applied the persistent felony offender tolling provisions as reasoning for its allowing these remote, and obviously the court recognized that they were remote and justified it by saying, well, he was in prison all this time. But that has nothing to do with how a 10 or 20 year ago crime bears on current credibility. That's a much different inquiry than an inquiry about, whether one can stay on the straight and narrow for a significant amount of time in order to, justify not imposing predicate felony time. Finally, with respect to the persistent felony offender sentencing, the court simply did not conduct a 400.20 hearing. The court never considered the defendant's history, character, and nature of circumstances of his criminal conduct. That hearing never occurred. And so the court clearly, all parties and the court were clearly under the impression that persistent felony offender sentencing applied to the third-degree burglary charges when that was not true. It should have conducted a second persistent felony hearing with respect to 400.20 rather than 416.
Mr. Lazier, on that issue, is it your argument that failure to run that hearing and then nevertheless sentencing your client to PFO, does that make an illegal sentence?
Yes, it does. That's my position, and I believe that the remedy that this court applied in Ellison, the Ellison case that I cited, would be appropriate here. Simply, just correct the court's error. The court went on the record saying it wanted the minimum sentence. So it did not want to do the 15 to life on the third degree. And this court can, in the interest of justice, eliminate that problem.
So because the court didn't do the PFO hearing, I'm just trying to follow it and I may have it wrong, but because the court didn't do that PFO hearing, but apparently based on the transcript sentenced your client to PFO status, that's one element of illegality. But would the other be that as sentenced, it exceeded what was permissible, because otherwise it might not even be a second felony offender. It might have been just a first felony offender. That was the only thing that you could sentence the defendant to vis-a-vis the failure to hold the PFO hearing. Am I close? And if I'm not, please tell me.
My problem is that he was properly sentenced on the persistent violent, and so there was a finding with respect to priors, and I think that may influence what happened with what should have been the 400.20 hearing, if that makes sense.
Thank you. Ms. Field?
May it please the court, Bridget Field on behalf of the people. First, with regard to the sufficiency of the evidence, there was sufficient evidence to corroborate that a burglary occurred. Mr. Patterson gave a detailed statement involving his participation not only in this burglary at 156 Albert Street, but also with the burglaries at Arm Prior Manufacturing and 33 Arthur Street. He knew details that only somebody who had participated in this crime.
But
Could
Ms.
it
Fields,
be-
sort of on the procedural issue that I mentioned before to Mr. Laser, you know what I'm going to, because you got it in your brief.
Yes,
You cite the Dunn case for the proposition that we can't make it a deemed denial, right?
um, I believe that this court can, but obviously I'm going to leave that decision to this court. I concede that the trial court did not rule
Right.
on the TOD motion. I believe as Mr. LaJour has argued, I think that this court has authority to address the issue, but if not, then I don't disagree that the remedy would be to go back to the trial court for a ruling. But again, I think that the record certainly has sufficient evidence of corroboration. Certainly, there's no requirement that every element of the crime be corroborated to his statement. So there is sufficient evidence there. With regard to Sandoval, first of all, it's not preserved. Second of all, the court properly considered the time that Mr. Patterson was incarcerated, and it was a significant amount of time. And the court did issue a compromise. The court did not leave unlimited and unfettered access to the people inquiring on all, I believe it was 5, if I'm not mistaken, prior convictions of the defendant. So there was definitely an exercise of discretion and evidence that the trial court had, contemplated the correct review of the Sandoval factors before that. With regard to the sentencing on the burglary case, the court definitely used discretion in entering that sentence. The court ordered that all of the sentences run concurrent. So when we speak about whether, imposing the minimum, certainly the court could have, these were all separate incidents, separate days. The defendant was eligible for consecutive sentencing on all of these charges.
But the provisions of the CPL and the PL that pertain here to sentencing as a PFO. The court has to run some form of a hearing and make certain findings in which you concede that the court did not do so here.
The court did have a persistent felony offender hearing specifically with regard to the first.
The PVFO.
To the PVFO, correct. I don't want to say initials because I'm going to mess it up, so I apologize. Anyway, yes, the court already had a hearing. So I agree with Mr. LaJour. I mean, those facts were already established and found by the court. The court made a written decision establishing that he had those prior convictions and that those prior convictions were eligible for the PVFO finding. So I think that it would have been, it would not have made any sense for the court to have had another hearing to establish facts that were in evidence and found by this court.
You would say practicality should control even if the statute says otherwise?
Yes. In this case, I think that the court could absolutely take judicial notice of its own prior proceedings, and practicality would make absolutely no sense. Not to mention that defense counsel defendant never at any time requested a second hearing in this matter. Defense counsel stayed silent on all of this. So I think that practicality dictates that it just would not have made sense under the circumstance to have that second hearing to make a finding that would have it would have had to have been identical. It was a decision by this judge made just prior to sentencing.
Thank you.
So if there are no further questions, I would rest on my brief.
I'll see any questions.
Okay, thank you.
Thank you. I think the next case on the calendar is numbers 121 to 123 by my count, and that is in the matter of Leonard P. Greenberg will just hold on a second while we bring in the other two folks. Counselors who are appearing by video, can you hear me okay?
Yes, Your
Yes, Your
Honor.
Honor.
Okay, I think you then go back on mute, and we'll go with Mr. Greenberg's argument. We're all set, sir.
Thank you, Your Honors. I'm representing Christopher P. For the sake of judicial economy, I'd like to look at point 2 and point 4 together because they kind of are linked. Because we do have to concede that the baby, Leonard, was obviously injured in some fashion. He had all manner of problems almost from the time that he was born. And that you also had the ineffective assistance counsel, which this court had already considered a few months ago when the mother's appeal, which was separate from this appeal. So yes, so we're not going to pretend that this child was not injured. What we are contesting, however, is that Leonard deliberately shook the baby or somehow caused the injuries because his theory has been, which I laid out in both in his testimony, Your Honors, is that that this was a baby that was born with all manner of congenital issues, such as amniotic fluid on his brain or excessive amniotic fluid, as well as a heart murmur. And that in order to successfully to rebut this type of a challenge, it's not enough for him to get on the stand and testify because he's not a doctor. It's not even enough for the lawyer to come up with, theories that he pulled from I mean, they could very well be valid, but a lawyer is not a doctor. He has to bring in the actual, as I said in the brief, only an expert can defeat an expert. So where are the doctors, as there seems to be a recurring pattern, where the DSS will come in and say, this happened, or there was a shaken baby, or the mother was mentally ill, or some other aspect to their case in chief, and then there's nothing really substantial to truly rebut it on the other side. So with those, that would be points 2 and 4. Point 3 was the derivative finding, and of course we would ask you to reevaluate that in light of my argument. And 2 is that if Christopher did not abuse this child, then he didn't derivatively abuse the other 2. No questions?
Thank you, sir.
Thank you, Your Honor.
Ms. Horvatis, I think it is. I think you're next.
Thank you, Your Honor. If it pleases the court, this is Melissa Horvatis on behalf of the Erie County Department of Social Services. I will keep my argument very brief this morning, just in response to what Counsel Greenberg has already stated. It is the position of the Department of Social Services that there was enough evidence deduced at trial to find that Christopher P. did in fact abuse this child and derivatively abuse these siblings. Whether or not counsel at trial decided to call an expert could quite easily be a strategic move. There is nothing in the record that suggests that they didn't call and speak to experts and decide not to call them. We don't know what trial counsel could or could not have done. There is also nothing that suggests that counsel that these experts proposed by Counselor Greenberg would have testified, would have been able to refute the medical testimony, and that the court would have come to a different conclusion.
Counselor, in the mother's appeal, I think there's a paragraph in our decision that addressed a somewhat similar issue, where it says something to the effect of, well, when you claim that it's ineffectiveness of counsel not to call this particular expert or treating physician, whatever it may be, you need to show something about what they would have said. Otherwise, it's speculation. I think we had that kind of language in the previous case. Would you say that applies here?
I believe it absolutely applies here, Your Honor. This case is obviously similar to the co-respondent's case in that the same evidence was presented at trial. The mother's counsel did have the opportunity in that case to explore and potentially call experts, as did counsel in this case. So I think it absolutely applies and is the same. In regard to anything else, the Department of Social Services will rest on our brief unless there are other questions.
Hearing no questions, we'll go to Mr. Fox. Thank you.
Thank you.
Thank you. May it please the court. Russell Fox, of counsel to the Legal Aid Bureau of Buffalo on behalf of the children. we would rest on our brief. We would point out, as Justice Kern has pointed out, that in the related appeal, this court found the contention that there was a failure to call an expert to be, quote, impermissibly based on speculation, that favorable evidence could and should have been offered on her behalf. I absolutely concur with that. I think point 3 of our brief really goes through all of the really comprehensive efforts and areas that trial counsel pursued here in cross-examining experts and developing theories. And trial counsel, I think, did a creditable job that we can't really second guess. Otherwise, we'd rest on our brief and invite any questions by the court.
Seeing no questions or hearing any, you're all set, Mr. Fox. Thank you, counselors.
Thank you, Your Honor.
Calling the next case, 124, in the matter of Jonathan M. versus Jessica N. Ms. Benedict, good morning. Can you hear us okay?
Good morning, Judge. Yes, I can. Thank you.
Great. Counselors, I think we're all set. Mr. Muldoon, good morning to you, sir. All set.
Good afternoon. Or good morning. Good morning.
Unless we really went through this calendar a long way, that worried me for a second.
You're asking a lot of questions when you're in the center, but you're not, it hasn't gone that fast. May it please the court. Gary Muldoon for Jonathan M. In this paternity case, the biological father of the child is my client. The mother had sexual relationships with another man and falsely gave information to my client that she was already pregnant when she and he had intercourse. Based on that false information, Jonathan accepted the situation and wished them the best of luck. She later sent him a photograph of the child, and he then found out later on, when she consented to a test, that he was indeed the biological father of the child, and within 2 months, he filed for paternity. We submit that the evidence established that Jonathan was the father of the child and that the court wrongly applied equitable estoppel.
Counselor, let's see if I can frame this just a little bit. The court sort of divided the hearing. There was the first phase, which addressed standing.
Yes.
And there was sufficient evidence to show that your client may be the father. No doubt about that. And then the second phase, which is where this appeal rises out of, is whether or not it would be in the child's best interest for your client to proceed with his petition, right? Because you make a good point that your client may indeed be the biological father. And your other point is this child will likely find that fact out at some point.
Yes.
But is any of that material or relevant to the question of what's in the best interest of the child? That's where I'm struggling.
Your Honor, I believe there is. The court did not allow testimony of the likelihood of the child learning of the father. And we were seeking to bring in expert testimony from a psychologist to testify that the child learning of paternity later on would be detrimental compared to learning of it early. Learning of it later on will be detrimental compared to learning of it early on. And there's a third department case that's cited in my brief that suggests that. That I think was a fundamental error by the court.
Because as I read your brief, that's largely the only argument you make, that your client's success is in the child's best interest. Because all the other evidence that appears is that the child has a very healthy, stable, loving relationship with the other father in the case.
I understand that, yes.
Right. And you don't dispute that.
I am not disputing that, no, Your Honor. But my concern in part is that equitable estoppel seems to be applied differently from the basic definition that exists in Black's Law Dictionary, which says to prevent one party from taking advantage of another going through false language or conduct, they mislead the person. And so estoppel should apply in this kind of a situation.
But don't the cases say that the relationship between the deception by the mother vis-a-vis the father don't really apply? That's not for the court to evaluate that.
Well, yeah, I would submit that that could be a misapplication of this concept, this basic concept of equitable estoppel. And here, while I agree that the father, that Mr. Mullen does appear to have a good relationship with the child, I believe that the testimony that we were proposing to introduce was that the delaying this information would be detrimental to the child.
Yeah,
And that evidence should have been.
That's your argument why the child why it might be in the child's best interest for the petition not to have been dismissed.
That is correct, yes.
Right, it seems like your stronger argument, at least in my view, is that the court just focused on the current situation with the child and that there is this strong relationship with the father and daughter. But later on, you weren't allowed to bring that evidence forward, that how that might affect the child. Is that correct?
Correct, yes.
Mr. Muldoon, are you familiar with the case that we issued a few years ago? I know I was on it back in 2016, Jennifer L. And it's in that case, we said whether estoppel should be applied depends entirely on the best interest of the child and not the equities between the adults. Later on that same decision, we said something to the effect, I think was relying on the Court of Appeals case in Shondell, that although a child has an interest in finding out the identity of his or her biological father, and I think this is quoting from Shondell, in many instances, a child also has an interest, no less powerful, in maintaining his or her relationship with the man who led him or her to believe that he is the father or the father. So we've got to look at whether or not that case law applies here too, don't we?
Yes, Your Honor. Yes. Thank you.
Thank you.
Morning, Randy Feimer goes Kerwin Law on behalf of respondents. I think the main case here is Shondell. And in Shondell, the court found that it would be a detriment for the child to find out that someone other than who she believed was her father her whole life, her absolute truth, if that came to light at that point, would be detrimental to her. That's clearly set forth in Shondell. Whether the child in this case finds out that someone else is her father that she doesn't know when she's 21 or 22, that's her choice.
But Counselor, doesn't it make a difference here though, that if the biological father was a billionaire and a wonderful human being, and the man that's being held out as the child's father is a horrible human being, then maybe it would be in the child's best interest if we were shift those facts slightly, right? But that's not the case we have here.
I agree with that.
That's the difference. The issue here is whether or not the child has a loving, stable relationship with the man she believes to be her father.
I absolutely agree with you. And as the record reflects, and even the petitioner has praised Thomas for his, for lack of a better word, fatherhood towards a child. The records were replete with how he takes care of her. He's a stay-at-home father. She calls him daddy. That's been her absolute truth since the day she was born. And there's nothing in the record to say that Thomas is not an absolutely terrific father. If the court doesn't have any other questions.
No questions. Thank you, sir. Ms. Benedict?
Yes, may it please the court, Mary Hope Benedict for the child. And Justice Curran, you pretty much summarized my argument on the relevant case law. I would just point out to the court that our client was 3.5 when this petition was filed, but she's now 6. So her relationship with her father, the father that she knows, has grown even stronger. And Mr. Moody admitted in his testimony that he had doubts about whether he was the father right from the jump, and he didn't do anything about it. He waited 3.5 years. Our client should not have to pay to have her world blown up because of his delay. She's a happy, healthy 6-year-old in an intact family. And I would ask the court to affirm Judge Mazza's decision because I believe that her reasoning is correct on the facts and the law.
Thank you very much, counselors. Next case on the calendar is number 126. Maria Guzman Martinez versus Luis Rosado. The appellant, my notes here, have submitted, and we're going to have responded by video. Mr. Cottrell, good morning, sir. Can you hear us okay?
Good morning, Your Honor. Yes, I can.
And it looks like Mr. Lavallo has submitted, so yeah, you're up.
Thank you, Judge. May it please the court, Tom Cochers for the respondent, Maria Guzman Martinez of Andrews, Bernstein, and Maranto. With respect to this court and to my opponent, I think this is a relatively straightforward case. We had legal malpractice committed by Mr. Rosado, the defendant in this matter. We had multiple attempts to conduct discovery in this matter. He had thwarted discovery. He had agreed to a settlement in open court with Judge Licata's then confidential law clerk.
Let's just focus on that, Mr. Cottrell, because
Sure.
In my book, anyways, from my perspective, that we know we don't have a stipulation in writing signed by the parties. So the question here, right, is whether this settlement was reached in open court. My understanding is that the most that happened here was a conference with the confidential law clerk for the judge and that law clerk's office, and that nothing, according to this record, happened in the courtroom or before the judge. Am I correct?
That is correct, Your Honor. And that settlement agreement was reaffirmed, and it was in the court's minutes a second time when Mr. Rosado agreed. And the terms of the stipulation were clear. I'm going to pay $50,000 in 3 weeks, and I'm going to pay $50,000, and I believe it was another 3 months. In the Smith
Is that in the record, Counsel?
Yes, it is, Your Honor.
This reaffirmance?
It is, Your Honor.
When you say reaffirmance, there was a letter or a phone call after that conference before the court law clerk, right?
That's correct. There was a subsequent conference with then law clerk Gary Wilson. I believe it was in March of that year. My apologies.
No, please.
Well, was that in court?
I believe that was on the telephone, Your Honor. And as I cited in my brief, in the Smith case, the court shouldn't apply the strict reading of CPLR 2104, where it would be to the detriment of the settling party. And I think the case law is very clear that settlements should not be thrown out if there's not fraud, mistake, collusion, or an accident. In some of the cases that I cited, counsel for the parties agreed to settlements and the court upheld those settlements. Here, we actually had an attorney who was representing himself make that settlement himself. Now, throughout.
Counsel, let me interrupt you here for a moment. This is a case where the terms of the settlement, from your perspective, are payment. Someone delivers money to the other party. That's how the case is settled. But there's a lot of cases that are settled with other conditions. Might be payment and then some acts, matrimonial cases. So your position here is that the events that took place in chambers, it appears, not even in the courtroom, that were not done before the judge and are not reduced to a stenographic record are nevertheless enforceable. That's your position?
Yes, it is, Your Honor. And I think there's case law supporting that the actual term in the courtroom is broad to include the judge's chambers or the chambers of the office of the confidential law clerk. I would say, and again, I'd rest on that Smith versus LaFranc case where the strict adherence to CPLR 2104 should be refused, where it's to the detriment of to the settling party, Your Honor. I would say this settlement was agreed to, and it was reaffirmed, and only then was this motion to dismiss brought here. And throughout the defendant's papers, in his earlier papers, and his papers to this court, he has never once disputed that he agreed to the settlement. He's merely relying on technicalities. And he's had ample opportunity to say, I never agreed to this. These were not the terms. I never wanted to reach this settlement. The court was wrong. The plaintiff is wrong. Everybody's wrong. They've never done that. If there's no further questions, I'd rest on my brief.
Counselor, well said. Thank you.
Thank you.
The next one for argument is case number 129, Usual versus Donahue. I think the appellate is by video. Mr. Stocker, good morning, sir. Can you hear us okay?
I can hear you. I can't see you right now. Can you hear me, Your Honors?
I will assure you that we have a panel of 5 justices ready to hear your appeal, Mr. Stocker, so we're all set.
Thank you. Good morning, everybody, and Happy New Year. I think our strongest argument in this case is that malpractice occurred, and there's a question of fact here. We submitted conflicting expert opinion. In my humble opinion, I don't think we need an expert in this case. There was no discovery. There was no depositions, no motions taken. They let the family member tortfeasor go, that they wanted the case to go on further, and the attorneys stipulated to discontinue that without receiving any money when $250,000 was available on her policy and an underinsurance policy of a total of $500,000. And the issues regarding misleading the clients and creating pressure to create a settlement on the other tortfeasor, I just feel that these are all questions of fact that should go to a jury.
All right. Counsel, let me, at least in my own mind, frame this. I'm not reading your brief as saying your current clients should have gone to trial. I'm hearing you say they could have tried to settle this case and get a little more money because they didn't get, and that's due to the fact that the daughter's carrier took a no pay position. Is that how I understand your?
Well, in my humble opinion, you'd go forward and try the case if it required such. It's a rear end car accident.
Except we have a deposition where Mr. Musial says, we wanted to get on with our lives, and we knew if we were accepting this settlement that our daughter and her carrier were not contributing in any way. We knew that.
I think later in the deposition that was further elaborated on and clarified. I believe we pointed that out in our brief.
I think you asked the question on page 103. Did you know that your daughter wasn't paying anything towards the settlement? Mr. Musial says, yes, we knew the time we settled the case.
Right. And I believe he says later in the deposition that after they put pressure on them to settle the case with the individual that hit them from the rear, he said, we called the attorney the next day and said, we want to go forward with our case.
Let's talk about that for a minute, because that I think may be one of your strongest contentions. Your position is that the stipulation of discontinuance was filed after that.
In my opinion,
just a minute.
In my opinion, I apologize.
Your position is the stipulation of discontinuance was filed after the Musials reported we don't want to settle.
Correct.
Well, when I look in the record, I couldn't find a stipulation of discontinuance, and I didn't find any information as to who drafted the stipulation or who filed the stipulation. There's the only reference to the stipulation is in your affirmation.
Okay. Well, the stipulation of discontinuance was drafted by the attorney in Texas.
Well, is that in the record? That's my question to you. Where in the record do you see that that the Donahue firm disregarded your client's instructions not to discontinue the action? Because that's what the expert says they did.
Well, I believe Donahue testifies at his deposition, well, we didn't want to go after the daughter's carrier, and in my opinion, they should have got different counsel then if that was their legal position. You don't disregard the client's instructions. And again, they're very clearly misleading the clients is the nicest way to put it, to take this settlement. But they should have found different counsel to go after the other insurance carrier. And yeah, try the case on a rear end car accident case with serious injuries. I don't know why any attorney would be afraid to do such a thing. I think people in this day and age understand insurance is involved and you're not going against your daughter per se. So to receive zero when potentially 500,000 is available, I think is shocking to the conscience myself. And we pointed to the appellate case law that malpractice can happen even if there is a settlement. We cited the Carbone case, which was a Fourth Department case, as well as other appellate cases.
All right, Mr. Stocker, thank you very much.
Thank you.
Ms. Brown?
Good morning. May it please the court, Megan Brown on behalf of the Donahue defendants. The order that granted summary judgment to these defendants should be affirmed because the settlement that these plaintiffs entered into with eyes wide open after 4 to 5 meetings and conversations with their attorneys and internal discussions among themselves was not compelled by any mistake of counsel. And that is what the case law requires in order to find malpractice in the context of a settlement.
That's our Chamberlain-Demanda case.
That's exactly the case, Your Honor. There was no mistake.
This is a situation where they wanted it over.
Exactly. I think in counting, in looking back at the depositions, Mr. Musial testified, I think approximately or at least 6 times. They agreed to settle. They wanted it over. He was going to settle. Mrs. Musial agreed with everything that her husband had testified to, and she herself said approximately 4 times, we agreed. They both acknowledged they had asked all the questions they had of their attorneys. They had talked it over. They were not going to go back to Texas for any reason. And the fact that then after the fact, they said, oh, well, now we would go back. If we thought we could get more, now we would go back. That we can't have every settlement opened up just because a settling party wakes up the next day or the next month or the next year and says, I wish I would have gotten more. That's why the law requires a mistake of counsel as defined by the case law. And that type of mistake is the kind of thing in the case that the plaintiff cited, that David case, where the settlement had to be limited to $25,000 because the mistake was suing it in the lower court and the jurisdictional limit, and they couldn't get more. That's the type of mistake.
Well, that's not entirely as I understand it, the Musial's experts' contention in terms of the mistake is we met with the Donahues and had a long discussion about the settlement. We had some conversations and we did sign some documents. Now, it's not clear to me whether the release was signed or the settlement agreement, because Mr. Donahue talks about 2 separate documents,
right?
But there's no settlement agreement in the record. There's the release in the record.
Right.
And it appears that the settlement agreement was signed later on, but that's for another day. The issue here is the Musial said the very next morning, we called Mr. Donahue and said, stop it. Don't file anything. Don't do anything. We've changed our minds. And the illusion here is that they went ahead and filed a stipulation anyway. That's what the expert says is it, and the from his review of the record is the mistake. Filing the stipulation when the client says don't do it.
But that, I think, is not what is borne out by the testimony or the record. First of all, to your point, there's no stipulation of discontinuance in the record. And from my review of the file materials, I don't believe that it was a discontinuance. I think it was a different document. I don't know. I'm not a Texas lawyer. But what I think the testimony makes clear is those conversations all happened before they agreed to the settlement. So even calling back, and it's shown in the emails that are attached to Mr. Kerman's affidavit in opposition to the motion, are the Musials still have questions. They're mad that the daughter's carrier is not paying. They're coming back in. Let's have another conversation. They entertained those conversations before signing the settlement. So it's my understanding that yes, here's the settlement. Oh gosh, our daughter's not paying anything. We call back. We want to do it again.
Settlement?
They signed the settlement March 9th.
That's the release, isn't it?
The release, yes.
Well, we don't know when they signed the settlement.
It's my understanding everything was signed the same day.
I think Mr. Donahue testifies that the settlement was signed sometime in April.
Yeah, but
and that seems to me to be more like a disbursement agreement, at the end of the case. This is what came in. This is what the attorneys are going to get. This is what you're paying.
Right.
Which really isn't the settlement. And you would agree with me here that the release itself is a little different than what we ordinarily see here. This was a release.
I mean, I don't know if it's like a standard Texas release.
Exactly. But Mr. Donahue is a New York lawyer.
Right.
Looking at this release, and it has some different language in there, right? It releases people who are not named in the release.
Correct. That's right. Yes. Yes, I think the unequivocal testimony from both Mr. and Mrs. Musial, though, was they understood that by taking the settlement that was offered to them, which they understood only came from the rear-ending driver, that the case was going to be totally completed. This is not a situation where we have parties saying, we thought the case was still going on. That it's absolutely clear. They knew this was the end. We aren't going back to Texas ever as against one driver or multiple drivers. This is it. We're mad that our daughter's own carrier is not paying anything, but the settlement increased by $100,000 over the span of a month. It was, that was the risks and benefits were explained to them. There's no mistake of counsel in saying it's gonna cost you more and you might get nothing if you don't take this settlement. I mean, that's their job. I think if they hadn't had that conversation, we'd be having a different appellate argument now. We didn't know that it was going to cost us money to go to Texas. So, I mean, there's no mistake here where the parties unequivocally testify multiple times in their depositions. We wanted it done. We knew by agreeing to this settlement, that was the end of it. And unless there's anything else, I'll rely on my papers.
Thank you, Ms. Miller.
Thank you.
Next on the calendar is numbers 130 to 131, Bellavia versus King. Counselor, we're all set.
Morning, Your Honors. May it please the court. Michele DeFranco on behalf of defendant appellant Deanna King. There are two central reasons that this court should reverse. First, that none of the conduct that Mr. Bellavia complains about on this contempt motion is covered by the divorce settlement. And second, the trial court awarded damages on a contempt motion without any proof of harm, and in fact, even went so far as to award damages while affirmatively finding there was no harm. That is wrong, and this court should reverse. Turning to the divorce settlement, the non-disparagement provision simply says that neither party shall demean or disparage the other in the presence of the minor
Counselor,
children.
could I slow you down for my benefit? My notes are behind you. If I understand you correctly, you're focusing on 2 points right now. Number one is, as I paraphrase it, that there was no violation of a lawful court order.
That's right.
And number two is that there was no proof of the monetary damages. I'm not trying to put words in your mouth. I just want to have it in my notes.
That's right. So the court awarded damages without making a finding of any pecuniary loss on the record. And in fact, in a portion of the order, even found there was no loss one way or the other and still imposed damages.
So the lack of evidence of monetary harm, so to speak.
That's correct. And also even going further to say there was no harm, and I'm still going to impose damages anyway.
Thank you.
So turning to the divorce settlement, the respondent argues that the Twitter posts and the blog posts at issue, that they don't mention him explicitly. He concedes that point. So he's left to argue that they refer to him by implication. And he does this by arguing that while some hypothetical reader one day could connect these comments to me, that misstates the law and misstates the facts. It misstates the law because the case law makes clear that courts apply an objective standard, that you only look, you keep yourself to the four corners of what is said, the four corners of what's said, and any extrinsic facts that are included. And so this court said in B Publications that without any extrinsic facts linking the comments to the person allegedly being disparaged, that doesn't violate a non-disparagement clause. And then turning to the facts of this case, a simple plain reading just shows that these comments at issue are just Ms. King's statements about topics of about her thoughts on things like politics, family values, informed by her status, not only as a survivor of domestic violence, but also as an advocate for other victims of domestic violence. So without any connection.
So one of your arguments, it seems that that she's claiming to be an abused person, and that because Mr. Balavi's not specifically mentioned by name, then that doesn't go far enough.
Let me go.
Seems to be a little bit out there.
So it's not just that. That would be on the sort of extrinsic, explicit disparagement.
Right.
But because there's no accompanying facts, it's not as if she said, my husband, the father of my children, the only living Iraq war veteran to receive the Medal of Honor. I think if she says those statements, then perhaps that becomes a colorable argument.
The well-known person that I'm talking about here, that people know who I'm talking about, but I'm going to act like I'm not talking about it. It seems
It's a little troubling.
The problem with that argument, though, is that now introduces intrinsic facts, that being the identity of the speaker. And really what this court's analysis has to be is looking at the text of what is said. So if I said, I know a staunch conservative who celebrated Roe versus Wade being overturned and paid for his girlfriend to have an abortion, it's not clear as to who that refers to. So that is why, without those facts, just looking at the four corners, it's not clear. And
just to follow up on Justice Green's question, wasn't there an order saying that all social media posts and references must be taken down? Or
the order, let me take a step back. There were two protective orders issued in this case, but those protective orders don't go beyond the scope of what the parties ultimately agreed to in the divorce settlement. The divorce settlement and the contents of the protective orders are all the same. So there's no added material in the, no added mistakes.
Unless I'm mistaken, it said no disparaging social media posts. I could be mistaken. That's why I'm asking you.
The problem with that is that goes beyond what the parties agreed to. And if that's what the respondent wanted, he should have negotiated that. This was a back and forth settlement agreement that the parties agreed that there were multiple edits made. We went back and forth on this. So to your point, if that's what he wanted, that's what he should have negotiated for. Instead, what he can't do is come to court and say, well, this is really what I want. I want you to enforce what I really wanted. He's limited by the agreement that he signed. Turning to the confidentiality provision, that just simply says that the terms and provisions of the divorce settlement should remain confidential and any information exchanged between the parties. Now, what happens is the respondent now wants to extend that to say, well, all the underlying facts of our divorce settlement, or our divorce, are covered by the settlement. And again, if that was the agreement that he wanted, that's what he should have signed. That's not what he signed. And he points to 3 demand letters and an underlying civil rights claim to say that the confidentiality provision was violated. But none of those actually violate that confidentiality provision. The first letter to HarperCollins just identifies 4 passages in his upcoming book that Ms. King believes are defamatory. That's not a term or provision of the divorce settlement, and that's not information exchanged by the parties in the divorce. Same thing goes for the letter that Ms. King's attorney sent directly to Mr. Bellavia about the civil rights claim. Again, it just outlines his theory that Mr. Bellavia violated Ms. King's civil rights. And the same goes for the final letter to HarperCollins. So none of this includes terms or provisions of the divorce settlement and doesn't include any information exchange. So it, by virtue of what the party signed, it cannot violate the confidentiality provision. Unless this court has any other questions on the divorce settlement, I want to turn to the damages portion. So the respondent's argument basically boils down to courts have unbridled discretion and can impose on a contempt motion, can impose just about any amount of damages. That's obviously not correct, especially when barred by various doctrines of substantive law. On the fees for the civil rights claim that the court ordered, the court decided to award the respondent only half of the attorney's fees, reasoning that, well, if he would have had to defend it anyway, even if there were no confidential facts that were included. Obviously, that's wrong for a couple of reasons. But first is that there was no confidential facts included. But let's even assume that there was.
Counselor, can I slow you down for my benefit, just in terms of the particulars? In terms of the monetary award, there was attorney's fees incurred in this action to enforce the judgment of divorce. Attorney's fees or a portion thereof incurred in the federal action, right?
That's right.
Then there was a fine.
There was a fine of $250.
And what else was there in terms of the damages or harm?
And there was, are you talking about the damages that were awarded in this case?
I'm sorry?
Are you talking about the damages that were?
I'm just getting the categories in my head
it.
straight.
Yeah, okay. And then the fourth category was a $2,000 bill to serve the underlying order.
That's what I was missing. Now, along those lines, I didn't see anything in your brief objecting to or otherwise addressing that portion of the order on appeal pertaining to the termination of the book royalties.
So that
do I have that right? You have not addressed that in your brief, and that's not part of your appeal.
So it wasn't argued in the brief, but the divorce settlement makes clear that only if there's an established violation of the underlying divorce settlement do the book royalties terminate. So basically, the book royalties rises and falls on this court's finding as regard to any violation of the divorce settlement. This coming to the civil rights, the fees for the federal case. So again, there were no confidential facts included, but even if there were, which again, we submit there isn't. The court itself found that either way, he still would have had to defend this case anyway. So the court, in fact, puts a finding on the record that there was no added harm. Remember, on a contempt motion, the court can only impose damages for the harm caused by the contempt. The court found there was no harm caused by contempt, but still decided to award half the fees. That was the court's reasoning. Even putting that issue aside, though, it's barred by the doctrine of collateral estoppel. This is a federal civil rights case. Mr. Bellavia has a remedy in federal court. That's really where he should have sought his fees. And the Court of Appeals has made clear very often that you can't commence a plenary action to recover fees that were available in a prior action. That's the 935th Court case that we cite in the opening brief. And then just concluding with the fees on this contempt motion. Again, it's inappropriate because there's no underlying contemptuous conduct. And also the rates that were charged are just not reasonable in this area. Courts have said that those rates are just beyond the pale for this jurisdiction. The last thing I want to say on the damages, unless there are no other questions, is that because the trial court made no finding of a pecuniary loss on this contempt motion, but awarded all of the fees on the contempt motion, lock, stock, and barrel, that in and of itself is reversible error. So even if this court disagrees with me on everything I said about the divorce settlement, and even if this court finds that the divorce settlement was violated, the failure of the trial court to make a finding of reasonableness as to the attorney's fees, that's reversible error. That's Costanza. I'll give you the citation, 213 Appellate Division 2nd, 1043.
Counselor, before you sit down, my last question will be, I don't see anything in your brief, nor have I heard anything today with respect to any argument about any purported lack of prejudice with respect to what the movement here established or didn't establish. That's not part of your argument. Do I have that? Is that fair?
There was no prejudice ultimately. We submit there was no prejudice.
My question is that in your motion papers below? Is that in your brief here? And it's certainly not part of your argument until I just brought it up.
That's right. It was not.
And don't go just because I'm asking and I'm a judge. Tell me if it's in there and I'll look at it.
No, the only prejudice that we argue is the respondent's own conduct resulted in prejudice to our client.
So that's your unclean hands argument, really. That's
right.
Not prejudice. Whether or not that equates, we'll have to look at. But okay.
Right.
Anything else?
That's it. For no other questions, I rest on my.
Thank you, Counselor.
Joan Casilio Adams from Buffalo, New York, on behalf of the respondent, David Bellavia. Stepping aside for a minute from a prepared speech, I want to address a few, I think, significant points raised with court questions and by the appellant. It says there's no violation of a lawful court order because the court order was simple. I've been doing this over 36 years. And I have never seen the task nor the actual court order like this judgment of divorce that appears, and I would call the court's attention to the records on pages 93 through 88, where there are detailed, extensive prohibitions, not just about denigrating. And my colleague here says that Mr. Bellavia should have negotiated a non-denigration clause. I can quote the words non-denigration on page 94 out of the judgment of divorce. And even further, he said, if he didn't want her to post it on the web or in a blog or in a tweet, he should have negotiated that. I call the court's attention that she was barred from doing that, denigrating or disparaging either party, the other, and specifically by means of electronic, including but not limited to electronic platforms, World Wide Web, posting, etc. These are quotes. So it is not an accurate representation that that was not only negotiated, but also in the judgment. Furthermore, it was specifically negotiated and in the judgment that nothing from the divorce, both documentation of tweets, accusations, pleadings, statements, nothing can be disseminated by a party.
Counsel, just
Yes.
to remind you, we have a video that's being taken, so you're sort of
I
behind the
know.
podium works best. I know as trial lawyers, we tend to move around, but
Judge Karen,
no problem
sorry,
at all. Just
I'll end up 10 feet away. Thank you. I'll remain
I'm sorry.
motionless if I can.
Great.
Thanks,
No,
no problem. I appreciate this statement. Page 93, judgment of divorce specifically states that nothing from the divorce may be disseminated. Not just disclosure, not just any in particular, any information or material obtained during the divorce. Anything in discovery, nothing can be released. Frankly, let's get down to the broadest. It was stipulated that the case would be sealed, not just under the domestic relations law, but permanently sealed, requiring, as we know, special application to open up the material. So I submit to this court a simple review of the judgment. I understand it's very detailed. We'll lay out exactly the prohibitions that were violated here. We established it. We were in court over an extraordinary period of time. When we first went to the court in February of 23, the appellant had no properly retained lawyer. She hadn't even put in her own affidavit. The judge began to make rulings, gave her extra time. We went another 5 months with 2 more appointed lawyers. She's had countless lawyers during the divorce and since. And then she was allowed to put in more papers. I submit this was intensively reviewed by Judge Devlin. She acted within her discretion. She made her own restrictive orders in January of 23, and Ms. King, Bellavia, violated them and even acknowledged in a discourse with the judge. When do I get to say my story? Can't I say my story? And the judge had a discussion with her on the record. You can't. I want to turn to something else that to me is troubling. Appellant says there's no basis for the award by Judge Devlin. Number one, we stipulated that this application for counsel fees, costs, damages, requests for a fine would be determined on papers. So one has to look at, consequently, and I'm sorry, the papers upon which that was based. If you look over 5 months, we submitted papers. We submitted my affirmations of attorneys in the federal case. She responded. There are multiple exhibits in the pages of approximately 810 to 880 of billing records, open billing records, not redacted, billing records from the federal attorneys, billing statements from the process service.
So you would say that there's plenty of evidence of the
Plenty of evidence, Judge Karen.
I'm going to take you back to whether or not there was a violation of a lawful court order vis-a-vis, and I'd like you to address this for my benefit.
Yes.
The communications with the publisher. Remind me, what were those and how did that violate the order?
Okay, specifically, Nate McMurray, her attorney, had written directly in late October 2022, and if you need the exact date, I certainly directly to my client's publisher within 2.5 weeks of a book going to the public.
And how did that letter violate the judgment of divorce provisions?
If you look at the judgment of divorce, no agent, not only are the parties restricted, no agent.
Where I'm driving, and forgive my memory here, it's a large record. So, but the substance of that communication was what in terms of how it violated the.
Number one, he denigrated my client. Those quotes are right in the letter and can be seen in the record. It's on the face of the record.
That letter's in the record.
Yes, it is. Number two, he submitted what he purported to be and ultimately was a federal court complaint that quoted the divorce, talked about the divorce. The complaint is in the record, specifically cited material from the divorce text, things that were not proven about abuse and the allegations. He submitted that complaint, recited what happened in the divorce from the perspective of the wife, and submitted that to my clients, obviously business associates being his publisher. I think when we talk about counsel, my colleagues saying there were no damages, there was no harm, I think it is axiomatic on the face of the record with my client having to hire lawyers, the publisher asserting their general counsel, having to address Mr. McMurray. And let's all just look. My client's hometown, the Batavian newspaper, for the first time, picked up the complaint, published in the place where these parties' children live, where they work, and where they grew up, the parties themselves, all sorts of accusations about the divorce, and published my client's photograph on the front. That was solely as a result, and it's not disputed, of that complaint being made public and picked up over the wire.
And I just needed to be reminded of those facts. I was drawing a blank on them. Thank you. I didn't mean to get you totally off the rest of your argument about damages, but go ahead.
Okay.
Your time's getting a little short, but you're still.
And I'm going to wrap up. The judge was well within her discretion to find contempt. I do not agree that she has to say on the record that the attorney fees were reasonable. That's implicit in her statement. She does address the attorney's fees originally in February, and then again when we all came together, but she addressed as we anticipated on the writings. And they are, despite the claims of appellant's attorney, my fees have been the same for many, many years, adopted and awarded by many courts. Many lawyers that do what I do charge more. So the reasonableness certainly was adopted by the court, ordered. And finally, I'd like to say, please, can we bring this to a close? And I hope what we've faced before this will be an end here today. And thank you for your consideration.
Thank you. The next case for argument is number 132, Middle versus Olean General Hospital et al. Ms. Markell, good morning. We're all set.
Good morning. May it please the court, Catherine Markell on behalf of Dr. Garg, the appellant. It's clear from our papers there are two issues. Did Dr. Garg meet his prima facie burden on the underlying summary judgment motion? We submit yes. And the second issue is, did the respondent raise a triable issue of fact? Before we get to those specific issues, I just draw the court's attention to the fact that the issues on appeal in this motion or in this appeal are much narrower than they were in the original motion. As we made clear with the settlement of several co-defendants, the only care at issue is the care that occurred on the return visit on February 27th. This is the visit where Dr. Garg, number one, made the correct diagnosis. Number two, he listened to the patient and his son. Number three, he reviewed the prior chart and acknowledged there was an assessment by a clinician earlier that day that noted the patient was at baseline. And number four, he talked to the patient and the patient and his son were unsure if that was true. The narrow question for this court is whether there was an ascertainable last known well time. The respondent would have this court believe the critical question is, did the patient present within the amount of time to give TPA? That is not the question. We cannot give that life-threatening drug without first having a last known well time. There has been no evidence in this record to refute that. The pointing of this court to the visit at 3 a.m. does nothing to alleviate that problem. Let's take a moment and even unwrap that a little bit more. Let's assume that this court looks at that. We know the last time the doctor saw him and assessed him was at 3:30. Is that within 4.5 hours? It is not. The last time a nurse.
By the way, Ms.
Yep.
Markel, your two experts have two different timeframes. One has 4.5 hours, the other has 3 hours. You just went with the 4.5 hours.
I did, for argument's sake. I think that makes it a little easier for the court. It sort of draws you to an issue that's not an issue, I think, but let's assume it's 4.5 hours. Over 4.5 hours is Dr. Khan's assessment. Over 4.5 hours is Nurse Lenchek's assessment. As you know, she's the nurse that does the last assessment before he's discharged at 6:02.
You would say no matter the time frame, sorry to interrupt you again, that as I said earlier, the panel is well familiar with the record of
Yes.
briefs, and your briefs on both sides were very good. So we've read all that. But so that's the crystallized problem, that is irrespective of the time frame, 4.5 or 3, because there was no evidence of a baseline that your client felt certain of, that therefore he did not commit malpractice, so to speak, by failing to administer the drug as alleged by the plaintiff. That's just, I mean, I don't mean to oversimplify the case, but sometimes I need to. That seems like what it comes down to.
That is it. And if we look at every other critical data point in this record, it echoes the truth of what Dr. Garg was faced with that morning, which is a return visit, which is people who are uncertain whether that was true. And if we don't have a last known well time, known being that critical operative word, we cannot administer TPA because it is immensely dangerous. And the risks and benefits do not play out if we give it beyond that time frame.
And if I understand your point further, and maybe I'm repeating myself, forgive me, but your point is you don't have to establish as a matter of law when the baseline was. You just have to establish as a matter of law what your client believed.
Correct.
Here's my issue with that, and this is kind of the difficult question for both sides. And I actually wrote it down, so let's see if I got it here somewhere. Should a jury evaluate whether it was reasonable for your client to be uncertain about when plaintiff was at baseline, given Dr. Khan's records that clearly indicate that at 6:00 whatever the time of discharge, the client was at the plaintiff was at baseline, and then further testified at deposition, Dr. Khan, that as of that time there were no neurological deficits, and that plaintiff was at baseline at the time of Dr. Khan's evaluation. Should a jury evaluate whether that was a reasonable conclusion for your client to conclude that despite that evidence, he was still uncertain?
I think there are two issues that we need to address with regard to that inquiry. Number one, we go back to the timeline. We're still beyond 4.5 hours in terms of when Dr. Khan actually laid eyes and assessed this patient. 3:30 a.m., unrefuted on that. And even nursing assessment, 3:43 a.m. We're already beyond that. So I think we can become focused on that point, but when we break it down, even if we look farther and unravel it, it does not matter for Dr. Garg.
The plaintiff would say the time the evaluation was completed was at the time of discharge at 6:02 a.m. You say, no, we should have it earlier, but isn't that a question of fact as to what was reasonable in that regard?
The expert affidavit from the plaintiff's expert did not consider the testimony, the handwritten notes of the plaintiff's own mother, where she described the state that he was in when he left that ER at 6:02 a.m.
Which would be contrary to the medical records of Ole and General.
Which would be contrary. And so when we hear contrary, we think, is there a question of fact, right? We think that.
No, let me, I'm laying it all out for you, Rafael, and then I promise I'll sit back and let you address it. But in that situation, you don't assume the truth of the mother's testimony. You assume the truth of the, effectively the movement, Ole and General being vicariously liable for Dr. Garg, I presume. You assume the truth of their medical records. And the medical records show that at 6:02, they was discharged because he was at baseline. That's how I read the case. And that's the difficulty I'm having with the argument, as good as it is. I see it's a tough case, but you've heard me out. Please address that for me.
So if we look at what the discharge was, what was he discharged with? Discharge instructions? He was discharged with generalized weakness. That was the discharge. And so there is some discussion in the record of him being at baseline during points in that hospitalization. But to get to that point would require this court to ignore the fact that the plaintiff's expert took no acknowledgement of the fact that there is a non-party witness who says he was stumbling out of that ER. Stumbling. That's not in their papers at all. And I think when an expert so clearly ignores a fact, a particular fact that hurts them significantly, ignores it completely, I don't know how this court can find that there's a foundation to believe that opinion is reliable. And so I would direct the court that there's obviously a litany of cases that support that argument and on that point. Does that address the court's question? Okay.
I think so.
So I think this brings us to my next point, or my last point really, which is that Dr. Garg would be before this court regardless of what he did that morning, depending on the outcome. And so what has happened here is, with a retroscope, this court and the plaintiff have decided he didn't get TPA and he had a stroke. Therefore, the case against Dr. Garg is you should have given TPA, it would have made a difference. If the outcome of this case was this patient had a bleed, then we would still be standing here. And the case instead would be the patient was unsure, his mother was unsure, the records reveal he was stumbling out of the hospital, and yet you still gave him TPA. And you were beyond the window. You weren't even within 4.5 hours of the last time a medical provider assessed him. We would be standing here either way. And there's case law to support the fact that in those situations, the doctor is going to be a defendant regardless of what he does, and that is improper. We are here because we're looking in retroscope at his actions, and because of that, I think this court should find that this decision from Judge Parker should be reversed. And I invite any other questions.
Ms. Marquette, we're all set.
Thank you.
Mr. Haberfield.
Good morning. May it please the court. You hit right into the case and you summarized it nicely. Had there been no medical record establishing that he was normal at 6:02 a.m., it's a completely different case. But he had that information. Dr. Garg had that information and chose to ignore it. It's our expert position that if you have a situation where the person who's having a stroke is unsure of their last known well time, and you've got a medical record that says he was fine at this time, that you go with, adhere to, and follow what the medical record says and act accordingly based on that.
Sometimes the medical profession says if it's in the record, it's gospel. If it's not, it didn't happen.
Right. If it's not in the record, it didn't happen, is what we hear often, right?
But how do you address Ms. Markel's point there at the end that the doctor would still be here if he had administered TPA because of all the evidence that shows that your client early in the morning, whatever it was, 3 a.m, was insisting that he had suffered a stroke. Of course, Dr. Khan disagreed with him and then discharged him. The mother's testimony that Ms. Markel just referred to, how do you address all that in this motion context?
With regard to any conflicting testimony, say, for example, Helen Middaugh's testimony, that's a jury question. A jury could disbelieve her or disbelieve the doctor. So that becomes a credibility issue for the jury to wrestle with. Because you could have, if the 4 of you came into court and all said A and Justice Hannah says B, a jury could say, we don't believe those 4 guys, we're going to believe B. So that's what gets us back to it being a jury question, summary judgment being appropriately denied in the case. There's another question. There was 2 parts to your question. What was the other one?
You asked me to remember that. That's not going to happen, but thank you.
All right.
As far as I was concerned, you answered my question. Maybe I forgot my second part, but thank you.
Then I'm going to shut up. So the issue becomes, as we often see in these cases, the classic battle of the experts. And that's what we have here, and that's why summary judgment should be denied.
Thank you.
You're welcome.
Paul, your next case for argument is number 133, the Genesee Fish and Game Protective Association versus Caprice Sullivan et al. What's up?
May it please the court, John Wells, Lazy Katzen, on behalf of the defendant appellant in this case. Your honors, the plaintiff failed to establish a prima facie showing of entitlement to summary judgment with respect to adverse possession and their quiet title causes of action. Most obviously, with respect to the element of hostility and claim of right. This court in the Galati decision made it clear that when there is a history of neighborly accommodation and cooperation existing between the parties, there is no presumption of hostility, and further, that there is an inference of permission that exists.
Counselor, I'm sorry to stop you here. I want to frame this a little bit. The plaintiffs have brought 3 causes of action. And they moved on the first and the third, right? The first cause of action is seeking title by adverse possession. The second cause of action is seeking an easement by way of prescription. You agree with me that there's a distinction between the first and the second causes of action?
Yes, there is both with respect to name and elements.
Right. So in the first case, we're seeking title. And in the second case, we're seeking just the right to cross over someone else's property without the vesting title.
What I would say, Your Honor, is that the second cause of action was not included in the motion for summary judgment brought by the.
That's right. But because what we've got is a lot of commingling of elements. I mean, there are similarities in terms of the causes of action. What needs to be proven to establish title by adverse possession and an easement by prescription?
Correct. And hostility is a common element shared between the two.
But there is something that's distinct between the two of them, isn't it? And that is what? Exclusivity, right?
Exclusive.
Right.
Yes, exclusivity.
And so let's focus in on that, right? Because the court below said that as a matter of law, the plaintiff has established all of the elements of adverse possession in order to ripen into full title, which would include the exclusivity prong. Correct? That's what the court below said.
Based on the decision, I'm not exactly sure of the court's reasoning, Your Honor. It appears as though they went with the adage that if you have established all the other elements, then you can piggyback in hostility as having existed.
Right, but let's focus on what's here before us, because as I read the order, the court does a number of things, including divesting, that's the language in the order, divesting the defendants of title to that portion of the road plus another foot.
Correct.
And there's also in the order, the defendants are to indemnify and hold the plaintiffs harmless. And there's another order paragraph where the plaintiffs are to indemnify and hold the defendants harmless for use and maintenance of the road.
There is some interesting language in the order.
Right.
Yes.
So that's why I want to try to frame this. So I think as I read your brief, your position is the plaintiffs failed to establish a right to title because of the fact that the record indicates that your clients used the road. They kind of did a circular path. They drove into their property on ATVs and they came back up on the east side of the road. So that way they didn't have to use west side of the road. And then there was a prior tenant, a farmer, who used the farm road in the past too. So that the road is used by a lot of people as a farm road. That's your point.
Correct. By my clients, family members, they used it for horseback riding, their tenants.
And so if there's a question of fact on that.
Exactly.
If there's a question of fact on who's been using the road, and if your client has been using the road, they haven't established all the elements for adverse possession.
Exactly. Yes.
They may have established the elements for prescription, but they didn't move on that.
Well, if we take that same analysis that you're setting forth and apply it to the hostility element, they would also lose on the prescriptive easement cause of action as well. That's why I focused so much of my energy on hostility. But your point is well made with respect to exclusivity and the inapplicability of the relief that they sought. Yes. But so, with respect to that element of hostility, it's the record that their witnesses made establishing a history of accommodation and cooperation between the parties for almost 100 years. And because of that, they now have a burden to rebut the inference of permission. The only thing that they say in response to that is, well, we have possession of the road. Possession.
Has there ever been anything put forth that would say that they gave permission? There was some hearsay that some permission had been given, but it was like kind of folklore. There was nothing.
Yeah, there are no documents in this case.
Oh, I don't mean just documents of whoever said that they gave permission is long gone, correct?
Yeah, Vinnie Friends, who owned the property starting in 1950, that's Capri Dix's great grandfather, who had this amazing relationship, according to the association, with the association, lived across the street from the road in
No, I
question.
understand that, but I'm saying specifically, no one ever said you have permission to do this. Permission was not asked.
There is no express statement in any of the
thank you.
deposition
That's
transcripts or in any document. I would point the court's direction to this court's court's holding that permission can be established by implication of the conduct of the parties. So if we look at the conduct of the parties, let's assume that there is no inference of permission, which I maintain has to exist because of the history of neighborly accommodation. But even if that history didn't exist, just look at the conduct of the parties and the testimony again offered by the plaintiff's witnesses saying, yeah, my dad and Vinnie Friends were great friends. Vinnie Friends let us use their property for all sorts of things. We would hunt on his property. We would take gravel from his property and use it to maintain our property. And according to the plaintiff's witnesses, that friendly relationship continued throughout the generations up until precisely June 21st of 2021. So on this element of hostility, they have to rebut the presumption of hostility. They can't rebut it by simply saying we are in possession. If they could, the inference of permission would have no meaning at all.
Mr. Wells, are you familiar with the case in the Court of Appeals from 2012 called Estate of Becker versus Murtaugh?
Yes, and that actually, I cited that
in your brief, was it?
I cited it in my brief. It stands for the same proposition as the court in Galati, saying that if there is a history of friendly accommodation and cooperation between the parties, there is an inference of permission that is drawn. In addition to everything else I've said.
But Becker went in the opposite direction from your point, correct?
I will concede I don't have a recollection of what happened in that case, Your Honor.
There is some question here about permissive use though, right? There's one thing to say you can use the old farm road, but really the association here did some other things too. They improved the road.
They paved it in 1993.
They did some other things to establish that their use in and of itself was, I think from their position, hostile to the exclusivity that your client seems to now stand for. That if your position is we have title ownership to that particular piece of property, they never sought permission to pave it. At least in the record, you don't allege that.
Well,
they never sought permission to maintain it from you. They never sought that, and there's no record that any permission was ever requested or received.
On that point, nobody can know for two reasons. One, Vinnie Friends is dead and could not testify in this case. And two, the association, which is a corporate entity with record-keeping obligations by its own bylaws, kept no records. we begged them to produce any record that would give us any information on this topic. So in the absence of information on that point, there's not much to say. If there are no other questions for this court, I will rest.
We're good. Thank you.
Thank you.
Good morning, John Whiting on behalf of the respondent. As the court is well aware, this is an adverse possession case. We have a handful of elements to deal with. The actual and open notorious elements are not contested. They're not in dispute. In terms of the continuous element,
let's focus on exclusivity. That's where I want to go on adverse possession. Don't we have evidence in the record that the defendants were operating motor vehicles on the road?
Yes.
They were using it along with members of your club.
That's correct.
And their tenants were using the road, right? So you're not taking the position that the road was exclusively used or only used by members of the club, correct?
Your Honor, a couple of points on that. The appellants used the road as any other member of the association would have used it. So that road, every member, every single day to get to and from the club to the association goes up and down that road. Up until 2021, the appellants were members of the association. So they would have used that road and they would have been had the legal right to use that road as any other member would have used it. And in addition to that, there is case law to support.
Fine about that. What about the farmer that was using that road to access the defendant's property under the lease to hay the field?
There's case law, Your Honor, to show that exclusivity does not mean that not a single person ever did not use the property. A casual user of property every once in a while does not negate the exclusivity element.
Good. Because as I read the order, it appears that what the court did was, and uses the language divesting the defendants of title. And you'd agree with me that title to the property is different than a prescriptive easement.
I agree.
Okay. And then in addition, because of the divestment, the court has a couple of other ordered paragraphs where your client is to defend or not defend, but indemnify and hold the defendant harmless for any failure to maintain on your property. And there's a reciprocal indemnification agreement.
Correct.
Right. So if the court were correct and we were to affirm and title passed by virtue of the continuous hostile use, exclusive use, does that then also create indemnification and other obligations of the landowners on either side of what appears to be the boundary line is moved from the center of the road to the edge of the road in one more foot? Right?
Correct.
So where did that come from? These reciprocal indemnification responsibilities?
I don't want to stray too far from the record, but we had
okay.
That was the
you didn't seek that.
No,
you didn't ask for that.
The appellants sought that. In our discussions between the lower court's decision and the actual issuance of the order, there was a lot of negotiation over ordered terms in the order.
Right.
And that was one of those negotiated points.
And to be clear, you didn't move for summary judgment on your second cause of action for the easement rights.
Correct.
You went for title.
Correct. And while we're on the exclusivity point, Your Honor, I'll keep going along those lines. In terms of maintenance of the road, the appellants and their predecessors in interest have never maintained the road, never. The respondent, my client alone, has repaired, blacktop, plowed, and otherwise maintained the road.
Never had to ask permission, they just did it.
They did it with no contribution or permission from the appellants or their predecessors in interest. And Ms. Dix in her deposition testimony readily admits that point. So maintenance is 100% in favor of my client. In terms of use, we've already touched upon it a little bit, but the appellants and their predecessors in interest were members of the Respondents Association until 2021. So up until 2021, the appellants would have used the road as any other member would have used the road. And by Ms. Dix's own admission, the appellants do not use the road to access their adjacent 45-acre parcel. Also, the road is the only entry point onto respondent's property from a public road. Therefore, any use of the road by the appellants up until 2021 was to access the respondent's land as members of the Respondents Association. 2021 is when this litigation commenced, and that's when appellants decided to terminate their membership in the association. And after any use by the appellants after 2021 would have been unauthorized by the respondent and totally irrelevant to this case, because at that point, the statutory period of 10 years had already run multiple times over. Approximately 3 years ago, this court right here in Rope v. Gibbs held that to establish the exclusivity element, the adverse possessor must alone care for or improve the disputed property as if it were his or her own, allowing others. Correct. And allowing others to use the property does not necessarily negate exclusivity. Our neighbors in the third department have also held that occasional recreational use by family members and neighbors does not negate exclusivity. And that was in Robinson v. Robinson. So to sum it up, in terms of exclusivity, we need not look any further than this court's holding in 2021 in Rope v. Gibbs, where this court put an emphasis on maintenance of the property. And as mentioned previously, the appellants and their predecessors in interest have never maintained the road. It's always been the respondent without any permission given or permission sought from the appellants. I would also like to touch upon the hostility element. We've touched upon the presumption. If all other elements are established, then presumption is presumed. And that presumption can be rebutted if there is neighborly cooperation found by your honors. And that point is argued by the appellants. All that does, that rebuts the presumption of hostility. Even without that presumption, it's clear that the respondent's possession has been hostile. And as the court is well aware, hostility in this context does not mean being outwardly hostile in its traditional sense. All it means is that there's been an infringement on one's rights. And the appellate division is replete with case law to this point. And
you cited that all in your brief for us, right?
Correct. Yep. Just one example, Your Honor, just to emphasize it, hostility, to prove hostility, all that is required is a showing that the possession infringed on the owner's rights, even if inadvertent or by mistake. And also a party claiming title by adverse possession is not required to show enmity or specific acts of hostility in order to establish the element of hostility. As was touched upon already, I'll just mention it again briefly. In terms of appellants arguing permission to try to muddy the waters, there is zero evidence of written permission.
And Justice Smith asked that question before. There's nothing on the record that supports that concept that there was, that there was express permission, correct?
Correct. And any claims of implied permission or verbal or oral permission to use the road, there's zero evidence of that. There is evidence, we will concede, the permission given to members of the respondent, individual members to go onto the 45-acre parcel to hunt, to fish, to take gravel. There is zero oral permission, evidence of oral permission showing that there was permission given for the road specifically.
Counselor, you should be mindful of your time and maybe consider a conclusion at some point.
Understood, Your Honor. I would like to just mention here in my last minute or so here that Judge Devlin did do a site inspection that's cited in her order. And also, I think the legal aspects of this case are firmly in our favor. In addition to that, equity is clearly in our favor. There's two parties here. We got one who's an association of over 1,500 members and over 20 year-round residents. And the other are two individuals who happen to live across the public road, Griswold Road. One party is an asset to the community. The other thinks it's a good idea to regularly dump manure next to their neighbor's property, especially on holidays. One party has blacktopped and repaired and plowed and maintained the road for several decades. The other thinks.
This is all in your brief.
Understood, Judge.
We're well researched and well presented, so that's all. We'll continue.
I appreciate your time. I ask that you please affirm. Thank you.
Next case for argument is number 134, which is Freeze versus Danforth.
I'm having flashbacks to first year in law school. I haven't heard the term adverse possession in 38 years.
We have a lot of subjects here, Mr. O'Connor, that is for certain.
May it please the court, I'm Jerry O'Connor. I'm here on behalf of the appellant third-party defendant, Rochester Davis Fetch. I fully briefed everything.
You cite a case called, I think it was with a T, Tancari or something?
Tanksley.
Tanksley. And then that case was cited in another case later called Carpentieri.
Yes, both mine.
Right. So if I read your brief correctly, and I don't mean to steal your thunder, Mr. O'Connor, and other members of the panel may have a question, but you have at least a minimum alternative question that with respect to the second element of the analysis, the intent for revocation, you would say at a minimum, there's a question of fact.
Absolutely. Minimum question of fact. However, I think what Danforth wants the court to buy, and unfortunately the trial court agreed, is that by signing this contract initially, Rochester Davis Fetch was automatically in default of the contract. The contract said it had an entered in date for July 19th. It wasn't presented until after this accident happened, and one would make the assumption that that's what triggered the contract, that an accident occurred and they wanted to pass the loss on. However, when you look at the contract itself, one of the provisions to provide insurance said immediately upon starting work. Well, the work had, if not been completed at the time of the accident, was substantially completed. And at that point, the insurance provision wasn't in place because Rochester Davis Fetch didn't have this contract. So they were in immediate breach of a provision of this contract that couldn't be repaired. And as a matter of fact, when a tender was made that was declined by the insurance company, basically saying that under the terms of our policy, a written contract had to be in place at the time of the incident or accident.
Or based on the case law that you cite, that there has to be an acknowledgement in the contract that says that we're applying this retroactively, which.
Yes, which is also missing. So, you know, I think it comes down.
They're arguing that these parties had contracts between themselves at other times. Is that correct?
They had three prior relationships.
Right, and they did cover the insurance. So since you don't get to rebut them, he's going to say that. What do you say to that?
Well, only one of those back in 2014 covered the insurance. The other two times where Rochester Davis Fetch was hired by Danforth to do any work, that was handled by purchase order. Here, what we had was somebody approaching somebody at Rochester Davis Fetch saying, we need this work done. They agreed to do it. And then after the accident, being presented with kind of a comprehensive contract that says, you not only agree to a defend and indemnify us, but you also agree to insure us. One of those aspects being impossible, given the fact that the contract wasn't entered into, despite the entered into language in the contract, but it wasn't signed until after the accident happened. I don't know if you need anything else from me. Hello, Judge Smith. How are you?
All set, Mr. Connor. Thank you.
Morning, Your Honors. Tom Gaffney from Lippis Mathias on behalf of Danforth. I'm fine cutting to the chase. I know we've been here for a bit this morning, and Your Honors indicated.
You've waited the whole calendar by all means, but you know, we have read the record in the brief and we're familiar with the case law, but go ahead, please.
I mean, I think our position is clear that this is equivalent to the Mann case, which is where the agreement was very clear and the court found that it ought to be applied retroactively. The other cases, Meeben, which was cited by opposing counsel, had a blank where the date was when it said as of. It was blank. That's not what we have here. We have a very specific date, and it was entered into and made as of that prior date. I don't think that they can simply go, oh, we don't agree with it or we didn't intend it. That's what the document says, and it's unambiguous. So I think unless there's a mutual mistake or unilateral mistake with some fraud, I think it's somewhat inescapable. And I think that's what MAN stands for. The Tinksley case that Your Honor talked about before, they did apply it retroactively. But in that case, there was an admission that they intended to. But that doesn't mean that's the threshold. That was a fact that was helpful for them in that case, but that does not mean that that fact is required. Here, the language is absolutely clear. The last case that was cited was the Guthorn case. And in that case, it wasn't as simple as we didn't intend it. There was actually reference to a prior executed contract that may have different terms. That's what created the issue of fact. The issue of fact was not created by someone saying in an affidavit, we don't agree that the language we signed means that, because they have to live with the unambiguous language. Guthorn was easily distinguishable in that regard. The biggest thing for me, Your Honor, is RDF offers, and I said this in my papers, RDF offers no explanation what that language could possibly mean other than it should be applied retroactively as of that date. In other words, they want to read that language made as of, executed as of, they want to read that right out of the agreement. New York law is clear that you can't do that. So on the retroactivity, we believe as a matter of law, we've established that very clearly, and they've not rebutted that sufficiently. With respect to the negligence issue, again, it's fairly well laid out in my brief that the only thing they reference is could have been, might have been, it might have been on the demo. There's simply not enough there to rebut our sworn affidavit saying we hadn't worked in that vicinity in some time, especially when the allegation is dust on the floor. I'll leave that one to the brief unless there's other questions. The one thing I really would like to highlight, though, at the end of Appellant's brief, he talks about how it would be improper for this court to issue a conditional ruling on summary judgment. I want to make clear that the idea of saying, as a matter of law, this can be applied retroactively is not a conditional ruling. The cases that were cited do not talk about retroactive application. It's when somebody moves for summary judgment saying this indemnification, we are entitled to indemnification. That's what those cases are asking for. And the courts say, well, wait a minute, we got to figure out whether you're negligent or not. In this instance, those cases do not say that this court cannot say it should be applied retroactively based on the evidence, and then later on say, we'll see if they're found to be negligent. So this is different, and this court can, as an alternative, say this should be applied retroactively as a matter of law, and yet leave the negligence question as a question of fact for trial. If there's no further questions, I'll rest on the briefing.
We're all set, sir.
Thank you, Your Honor.
Next case for argument is number 135, Ditech Financial versus David B. Bailey et al. And I know we have Mr. Dodones here for the appellant, and we're having Ms. Mello from on video. Counselor, can you hear us okay? Excellent. Okay, we'll proceed with the argument. Go ahead.
Good morning, Your Honors. Thank you. May it please the court, Kyle Dodone, Rupp Falsgraf LLC on behalf of defendant appellant Jepco OGM Resources. It's appellant's position that the trial court's order granting judgment to the respondent should be reversed for a myriad of reasons, as neither law nor fact support the trial court's decision. As a preliminary matter, this is exactly the type of case that the Foreclosure Abuse Prevention Act was enacted to address.
Before you get to those arguments, let's go back just a bit. This action was commenced in 2018. Has your client filed or served an answer?
My client has not served an answer in this case. They filed a pre-answer motion to dismiss. The litigation continued in terms of the motion to re-argue.
The plaintiff's position here is that none of these arguments can be raised because your client is in default. And that was the thrust of the opposition. But I didn't see a response to that in your reply. And do you have a response to?
Our response to that, it does involve FAPA because of the change, because of the change in the RPAPL, specifically 1302-A, which allows standing to be raised by a foreclosure defendant subsequent to the time for a responsive answer. It can and should be viewed by the court. Now, in response to that, I understand the respondent mentions that because we're in default, standing cannot be raised. That is not the case. That is not what 1302A says by statute. The only litigation, because FAPA is still very much in its infancy, passed only enacted in December of 2022. There are no cases that adequately decide this particular position. There are two cases that come out of the second department, which seem to concern that because you're in default, that you cannot raise standing at any time. That was the intended purpose of FAPA. That's the reason for the change of the RPAPL to affect that change against 3211E. So I submit that it is appropriate. It was the intention of the defendant to defend, to appear, and beyond that, there was an invitation from the court to answer the motion and provide supplemental briefing on the issue of FAPA, as well as the substantive issues that were before the court. So I believe that's a red herring and nothing more than a distraction. So with that, again, this is a third action filed with respect to the mortgage, the first going back to 2010. Prior to FAPA, lenders were permitted to manipulate, as here, the dates of the default, to massage, to manipulate the statute of limitation to their advantage. FAPA certainly put an end to that. And that's what brings the ability for the appellant to come before this court to address specifically the issue of standing. It's a threshold issue. It must be resolved before the respondent is entitled to any relief. It is not waived, even if it's not raised in the responsive pleading, even if it's not raised in the pre-answer motion to dismiss, which it certainly was. The trial court failed to address this argument, holding only that the appellant was in default for want of pleading. The motion for leave to submit late answer would have been futile in this case. In a situation where the court has invited the defendant to respond to the motion papers, has invited the defendant to provide supplemental briefing with regard to FAPA, the substantive issues that were before the court, it would not have been necessary or appropriate to then make additional motions when the matter was properly before the court to begin with. The appellant appeared, filed their pre-answer motion, had a motion to re-argue, all of which were largely ignored, all the issues before the trial court. The appellant intended to and did, in fact, impose the motion. Now, as I've mentioned, with regard to RPAPL 1302, the respondent will certainly say, no way. I have two cases from the second department. You must follow that. I don't think it's any stretch of the imagination to say that the second department has a very large volume of cases. They tend to be more activists and have a more likelihood to get to these issues in a quicker fashion than we might see. It's no surprise that they are there before the fourth department is, but that doesn't mean that their decision is necessarily correct and addresses all of the issues. This is not a first past the post. The winner does not take all in the decision. So with that, I say 1302 does not provide that standing. Specifically, I would say that this conclusion by the respondent is nonsensical. A fair reading of RPAPL 1302 does not say that it is waived. It simply does not say that. In fact, if you look at the last sentence of RPAPL 1302-A, it permits a defendant appellant to challenge the judgment of foreclosure and sale if it is obtained on default. So by that logic, if we are permitted from raising it at this point because of our default, we are only then permitted to raise it once a judgment of foreclosure and sale has entered. It is nonsensical to make the appellant wait for the judgment to enter when the issue can be addressed at the early stages of litigation. And for that reason, I say it is an issue of first impression to this court, and it should be resolved in appellant's favor. As part of the appellant's position on standing, I'd like to highlight the fundamental misunderstanding of the assignment of this mortgage. Because of this process of assignments, because of the technicalities that are involved with mortgage assignments, the respondent has been permitted to continue its efforts to enforce. Make no mistake, the original default on this matter goes all the way back to 2010 from the original mortgagor, Mr. Bailey. Affidavits regarding his default, affidavits regarding his failure to make payment after that date are in the record, largely undisputed, however, are manipulated by the respondent in that their complaint provides in the 2014 action a different date of default, in the 2018 action yet another different date of default. It's nothing more than manipulation of the dates. But with the technicality of the mortgages, I just want to highlight the endorsement issue on this because I think it's important. I think it's technical issue, and I think it is largely overlooked when in the world of mortgages. This particular mortgage note was not freely assigned. What it was is it was assigned, or I'm sorry, transferred by an endorsement in blank, and that is significant. When you have an endorsement in blank, it must have strict compliance with UCC 3-302. In that respect, only the holder is entitled to enforce the note. Now, we have an unsupported allegation in the complaint that the respondent is the holder, was the holder at the time of the commencement of the action. We do not have, and I think this is the more important part, any information in evidentiary form as to when they became the holder, how they became a holder.
Time out on that, Counselor. Just that's an allegation in the complaint, right?
Yes.
They have that standing that they are the holder, correct?
Correct.
And by virtue of being a default, right, your client has essentially admitted that allegation in this default posture. Isn't that the law?
They've raised the objection to it in the pre-answer motion to dismiss and in the motion to re-argue. As it stands today, it's the position of the respondent that it is not properly before the court. We submit that under the RPAPL, which allows us to raise the issue of standing, even at this late stage, it is properly before the court.
So that trumps our case law that says when you're in default, it effectively admits all the allegations in the complaint.
Yes, because our RPAPL 1302-A as amended allows a mortgage foreclosure defendant specifically the ability to raise standing at a later date.
We'll look at that.
Mm-hmm. And with that, with this inefficient transfer, unsuccessful transfer, we have no information evidentiary form from the respondent, the custodial records, an affidavit from somebody with personal knowledge as to the actual transfer. What we have are these so-called corrective assignments. The respondent offers them, we'll say with equal weight as part of the complaint to shore up this defect in the assignment. They're not sufficient when there is a transfer of a blank endorsement. The assignments do not correct that error. And for that, we don't have a proper transfer. We don't have standing. An appellant's position, raising it even at this late date, is still correct. Now, with regard to the statute of limitation issue, there's no dispute that there's a 6-year statute of limitations on the mortgage foreclosure action. Despite determining that October 1st, 2010 was the first and proper date of default, respondent disregards this information, falsely states that the first default isn't until December 1st of 2012.
That's assuming that there was some sort of counterclaim filed in or about 2010, correct?
So there's a couple of potential issues for starting the date of the default. The earliest of which is the date of non-payment. That would be the October 1st, 2010. In
So
terms,
no payments for this property on the Chautauqua Institute grounds for about 14 years.
that is correct, Your Honor, and that's undisputed.
But getting back to this, and forgive me for not understanding if I don't have this right, but I thought in terms of you're trying to point to there being an acceleration of default and measuring the statute of limitations from a certain point in time, that point in time you were basing it on a purported counterclaim that the mortgagee at that time purportedly commenced. And what I'm driving at is, I have to tell you, Mr. Stone, I've looked. I can't find anything in this record other than, I think, Mr. Bailey's representation that it was there, but there's no support for that I can find in the record. At least insofar as your statute of limitations argument is concerned, that strikes me as a real problem for you. How do you address that?
Yes, Your Honor, and I do agree with your position. There are different measures in terms of the statute of limitation, one being the first date of default. And with that, that statute of limitations will continue with each individual payment up until there is an acceleration. It's the appellant's position that there was an acceleration in 2010 as a result of the matter that was filed in 2010.
Well, we have no evidence of
In
that.
In terms of evidence that's provided to the court, we've provided the affidavit of the attorney that was handling that specific matter, Attorney Arthur Bailey. But more specifically, we've provided an affidavit from David Bailey, the mortgagor who is now deceased, as to his recollection regarding the foreclosure counter.
And we got to look as whether that's enough evidence of a court document.
Understandable, Your Honor.
And I know we've asked you a number of questions, Mr. Dillon. I know this is an important case for your client, but I'm going to ask you to wrap it up fairly soon because
Understandable. Thank you, Your Honor.
We've taken up your time.
Okay. With that, I just want to state, that this type of factual dispute, the type of issue that's before the court is exactly precisely the type that should be resolved with the proceeding before the trial court. And these specific issues that you've raised with regard to the counterclaim and exactly what it says are part of our request for additional discovery for documentation regarding not only the notes, the transfer, but also what happened to the respondent's recollection as well as the courts in it. All reasons why this matter should have been maybe held in abeyance, if not certainly denied. That's why we have the additional issues, all pending, of course, on FAPA and the changes that
You've
resulted.
addressed all of that, your comprehensive.
Yes, Your Honor. And so with that, we simply would say that under the Foreclosure Abuse Prevention Act, we ask that the court give deference to that act, review it as a case of first impression, certainly as FAPA is applied to this in this court, and reverse the trial court's decision in order.
Thank you, sir.
Thank you.
Counselor, we're set for the respondent.
Good afternoon, Your Honors. Eliza Malouf on behalf of the respondent. So as Your Honors noted in my colleague's argument, all of the substantive arguments that have been made aren't even properly before the court because the appellant is in default. There was never an attempt to vacate that default despite the fact that it was raised. And in fact, there was never even a response to the allegations that they're in default until just now when the court asked my colleague about the default. The argument that FAPA somehow allows appellant to raise the argument of standing even if they're in default is not anywhere in FAPA. The case law on this issue is really, really clear that if a party is in default, they cannot raise non-jurisdictional defenses, including the issues of standing. That's very, very clear. And FAPA does nothing to impact that. But
And
even if the court...
I'm sorry to interrupt you, but the appellant argued something to the effect of a lot of that case law comes out of the second department. But nevertheless, it's appellate division authority on this issue that you would rely on, and you would say it's at a minimum persuasive for us.
That's correct, Your Honor.
Okay.
Do you mean on FAPA's applicability, or I'm sorry, maybe I misunderstood the question.
You're all set. Go ahead, Counsel.
I think I may have misunderstood the question. Are you asking about the second department's applicability of FAPA, or are you asking about inability to raise standing?
About the default issue.
If you're in default. Yeah, that's correct. I would argue that that's persuasive.
That's your fundamental point, if I understand it correctly, that they're in default. They don't have the standing to raise these other issues so long as they're in default. And if I read it correctly, there was not even any contention that there was a reasonable excuse for the default.
That's all correct. Yeah, the court doesn't even need to reach the other arguments. But even if the court does decide to consider the other arguments, the court should still rule in our favor. On the issue of standing, it's very well settled case law that attaching a copy of the note where it's endorsed in blank to the complaint that is filed is a prima facie case to support standing. That is what happened here. There's no argument refuting any of that. And there's no evidence that contradicts the prima facie case of standing. The note was attached to the complaint, and that is well settled. So the standing issue is a red herring, even under fact. Again, with the action being timely, the entire argument on the statute of limitations turns on the existence of there having been a foreclosure counterclaim in the 2010 action. Again, there's absolutely no evidence of that. The clerk of the court did reach out to the parties before oral argument to ask for evidence. One of the documents that was submitted in response to that request was NYSIF document number 31, which is the minutes from the 2010 action. And it shows that no answer was ever filed in that case. And it makes sense that no answer was ever filed because the motion to dismiss was filed and that motion was granted. So there's absolutely no evidence of counterclaim. Appellant has never presented an evidence of counterclaim other than these self-serving statements showing that or stating that some counterclaim was raised. But again, that there's just no actual evidence of that. And so any statute of limitations argument is barred. The appellant makes a lot about the fact that the date of default is 2012 and this complaint was a different date. That is because we do acknowledge that each individual installment, once it's missed, has a 6-year statute of limitations. So the date of default was advanced to account for the fact that it was 2 years past the statute of limitations to collect on the 2010 default. But that doesn't mean that the statute of limitations has somehow run on the entire debt, which was never accelerated until at the earliest, the 2014 action. But we would argue the 2014 action also didn't accelerate because the court found there was no standing in that case. And so that also can serve an act of acceleration. But regardless, we're within 6 years. Again, FAPA is a red herring because there's nothing in the statute that that allows a defaulting party to argue standing, even if they're in default. And for the rest of the issues, I'm going to rely on my briefing because they weren't raised in oral argument unless the court has any other questions.
No other questions, Counselor. Thank you very much.
Thank you, Your Honors.
The next, and if I might count, the last case for argument today is number 136, Gorman versus Mooney's 9. We have an appearance by Mr. Doyle, right, on behalf of the appellant, and you probably have heard that Ms. Salino has submitted.
Yes, she called me this morning with a family emergency and gives her apologies, and I tortured her mercilessly for 30 seconds and told her I would tell her exactly what happened today.
Well, Mr. Doyle waited all day to have your argument. Go right at it.
As long as I still have my voice, I will do what I can. I've been under the weather with a cold. This is probably the simplest case you're going to be dealing with today. I mean, Mr. Gorman is riding his bicycle down the sidewalk. There's an incline. He's going about 12 miles an hour. Somehow he loses control of his bicycle and ends up riding into a fixed sign in the grassy area between the sidewalk and Mooney's Sports Bar and Grill Restaurant.
He's coming over the overpass, whatever you call it, over
400.
On the 400.
Yeah.
The Union Road exit from the 400 is right there.
Exactly.
The restaurant, it has changed hands, I think, on not that matters to anything, but I know where it is.
Yes, exactly. It used to be Sinatra's, I think. But I think when it was Sinatra's when you went there, it was a fine dining establishment.
Yes, I think it probably will.
Like full of buffalonian.
But poor Mr. Gorman was going at a pretty good clip. And he ran off the sidewalk. He got distracted. Well, any number of explanations were given for that, but he hits the sign and he hits it hard.
The facts are pretty straightforward. And your point is this is open and obvious. He lives around the corner, if not right around the bend. It couldn't be more open and obvious if you tried.
Exactly.
So therefore you win, is what you're saying.
Well, yes, and there's no inherent danger to this thing.
Well, not only that, he also admitted that he's well aware of that sign and
he's seen it 1,000 times.
Yeah.
And more importantly, from our point, there's nothing in this expert's affidavit that it was unreasonably safe, other than he was hurt because he ran into the.
Unreasonably dangerous.
Unreasonably dangerous, yes, I'm sorry.
Yeah, and that's what his argument was. And then he goes a bridge too far, so to speak, and he starts talking about how if the sign was a different height, he would have merely been catapulted over it rather than
And
impacting.
Mr. Doyle, just so that I give you the loaded question. So you made the trek, you've waited here all day, you probably came through some snow. But here's what's bothering me, is I read your expert's affidavit. There is no basis, there, it seems to be conclusory with respect to the opinion that this property was in a reasonably safe condition. I'm not a fan of the inherently dangerous language that's used by some, because I don't know what it means.
Yeah.
But I don't think it matters. I think it basically translates to a defendant can get summary judgment if the condition is open and obvious, defeats duty to warn, and proves as a matter of law that the premises is in a reasonably safe condition. Naturally, I would go by the language from the PJI, including the verdict sheet that used to be in there, in any event. So I would say that that's your burden. I don't know where your client has met the burden on that second prong, what I refer to as the more general duty of a premises owner to maintain their premises in a reasonably safe condition. That's, for my book anyways, is the standard. Basso says it, Hagel says it.
Basso versus Miller, yeah.
You got it.
Yeah.
So forget about the duty to warn concept that's addressed by open and obvious, vis-a-vis the general duty of a landowner to maintain their premises in a reasonably safe condition. Open and obvious only goes to the plaintiff's comparative fault.
I don't disagree.
So that's the law. You just said it not too long ago in a case I was on. What I don't see in your expert's affidavit is anything addressing facts that establish as a matter of law that this sign that the plaintiff alleges shouldn't be there at all. I mean, that's the position of the plaintiff. It shouldn't be there at all. There's no permit for it. It's on the right of way. It doesn't belong there. And because it shouldn't have been there, that's negligence by your client for putting it there. And therefore, you didn't overcome that as a matter of law. You just heard me out, Mr. Doyle. It's my full question. Go at it.
Well, there's a lot there. And I'll try and remember everything. First of all, I don't think you need to get to expert opinion on this. I mean, it's just so commonsensical. I mean, you have a sign.
That's the open and obvious part. That only gets you to the duty to warn.
Yes.
I'm talking about the more general duty.
Okay, well, let's talk about the danger presented by the sign and what the plaintiff has to prove in order to get to a jury. And that is that there has to be some proof that it was inherently dangerous, Judge. And there wasn't any proof of that whatsoever.
Not reasonably safe. Again, I don't know what inherently dangerous means.
Okay.
In cases use it, but no matter what, that's my question. Tell me about whether you established as a matter of law that the premise was in a reasonably safe condition for a sign that the plaintiff alleges isn't supposed to be there at all.
Well, I don't know if that's my burden to prove, but we can prove it by the lack of evidence of any kind of
Lack of evidence doesn't get you there in summary judgment, Mr. Doyle. You have to prove as a matter of law that this premises with the sign that the plaintiff alleges shouldn't be there at all. That nevertheless, it was in a reasonably safe condition as a matter of law. That's really what I'm stuck on, and I'm looking for the counter.
Well, a couple of things, Judge. First of all, it's difficult sometimes to prove. I guess it's to prove a negative. I think that's the term that I want to use. I mean, here we don't have any evidence that there was any sharp object, impalement hazard, puncture hazard, nails or bolts in this sign. It was not painted in a manner such as to make it difficult to perceive to a pedestrian or even a bicyclist.
That's open and obvious. That's duty to warn. I'm on the more general duties.
Okay, but in terms of danger, in terms of elevated risk for those kinds of things, like where you have an object that has an exposed nail on it and rips someone's flesh to the bone or something like that.
And I noticed out of the corner, my Justice Del Conte has a question that I keep getting in his way. So I want to stop getting in his way.
I'm going to ask Justice Kern's question too, but maybe just in a little different way, right? I think what Justice Kern is asking you is the placement of the sign itself. The act of putting a sign there in that area, that right away. Isn't it your burden to show that that was not a negligent act, that it was reasonable to put the sign there in the first place? And let me just say, if I understood the record, wasn't there at least permission from the municipality to put a sign there?
There was the prior owner when it was, I think when it was Sinatra's.
So isn't maybe that part of the answer to this, that this was an area where signs go? There's a process to get permission from the municipality to put a sign there. This particular sign may have not satisfied all of those conditions, the municipal conditions.
Well, this particular sign had been subject to prior permits. It's when they changed ownership, the new owner didn't recognize that permits had to be applied for every, 2, 3, 4 years, something like that.
He never applied for another permit, but he was never cited by the municipality either for not having the permit.
No, never cited.
Asked to remove the sign.
So if I understand it, the sign was proper for some time, but that expired under the terms of the temporary permit.
That is my understanding as well. Right. And I think we have
to. Had the accident happened during the time that the sign was in place during a temporary permit, it would have been the same sign in the same location.
Well, the plaintiff wouldn't have been able to argue that it wasn't permitted, but otherwise everything else is the same.
Then they'd be suing the town.
They'd be suing
for issuing a permit the sign is on the right of way. It's not on your client's property. Do I have that right?
You know something, I'm going to have to double check that because oftentimes a municipality will have control over what goes in an area, even adjacent to a road.
Bear with me. You in your expert's affidavit in reply, he says that is a New York State right of way.
Okay.
That provides for the signage you see when you get off there and the lighting pole. So just so in case I had it wrong, but I read both experts' affidavits saying that's not even on your client's property. It's a sign that your client put on a right of way that belongs to New York.
I think the record, doesn't the record show that it's a right of way, but he owns it, but the transportation department still has a right to access that.
Hence the permit.
Right.
Yeah. That's why you have to have a permit. But it's analogous to a situation where someone parks their car on a public street and they the registration lapses and someone plows into it. I mean,
that's in your brief. What this
I love that argument.
We were using that argument.
Same thing. Right?
Yeah. But I tend to look at things in a very simple way, especially after sitting here for several hours and nearly losing my.
I learned about adverse possession.
like Mr. O'Connor said, I haven't heard that term in a long time, thankfully. But I don't know whether you need any expert witness testimony in this case. I mean, I think just looking at the sign, the photographs,
I'm sorry, but isn't
you're going back to open and obvious?
Yes, but it also goes to what kind of risk or danger or elevated risk of harm is created. It goes to whether or not the owner of the sign failed in their duty to make it reasonably safe.
Right. Counselor, isn't that a question? No, that particular question you just posed, that's not for us to answer. That's the jury's question, right? So if it's reasonably safe.
But there are times when it is so obvious that there is no additional inherent danger provided by a sign.
That's really the crux of your argument as I read it, Mr. Doyle. Do I have that right?
I would say it's one of the many.
I'm pinning you down.
One of the many cruxes of my brilliant argument, Judge.
Mr. Doyle, I didn't mean to cut you off, sir, but I appreciate your argument, but we all do very much. Anything further?
I don't think so. I think everything's said in the papers, and I have got about 30 seconds left to go with my voice anyway. Thank you. Thank you, everybody.
This court will stay in recess